to concrete action that can be taken by trade unions and employers' organizations. And the beauty of the ILO supervisory system is that the trade unions not only can file complaints against the application of ratified conventions by India, but also the trade unions from India can file complaints against non-application of ratified conventions in other countries. So the system allows this. As you know, the ILO is a tripartite organization, government, employers, organizations and trade unions. They play an equal role within our organization. And you know, on the one hand, governments are always tempted to give a kind of rosy picture how international laws are being applied in their own country, and therefore the role of unions and sometimes also employers' organizations in countries like Iran or Venezuela, they give us a more balanced feedback of the actual state of labor in any country. And that is why Mr. Narayan already with BMS has indicated how it can use the ILO. So I just have 3 slides, and I will just try to give you a general picture without becoming too technical, although many of you must be lawyers, so you shouldn't be bored by any legal details. But I'll just show you, and then whenever you have any questions, just let me know. You can write me an email. I have plenty of information, plenty of examples, how unions can file complaints or whatever the just legal terminology is. I can show you the way if you feel there is a need to use this system, and I would very much encourage you to use the ILO supervisory system, especially in situations where we have this international interdependence on migration. So Mr. Narayan already told us that there are 8 core conventions at the ILO which we consider basic labor human rights conventions. And out of these 8 conventions, India has only ratified 4, the ones on forced labor and discrimination. But with the approval by Cabinet of the amendment of the Child Labor Act, I think it's called Prohibition and Rehabilitation, 1986, once Parliament, I guess in the winter session, will approve the amendment of the Child Labor Act, automatically the government will follow with the ratification of these 2 child labor conventions. So it will happen, let's hope, early 2013, that India will have ratified 6 out of these 8 ILO core conventions, because it is true that India is the only major member state of the ILO that hasn't ratified these 2 child labor conventions yet. And then the Freedom of Association conventions. The Joint Secretary Labour, Mr. Pandey, has assured me that now there is a serious looking into ratification of Convention 98, which is promoting the use of collective bargaining. And I must say that Swamiji this morning, Mr. Chaturvedi, was very, I mean, he could have been an ILO colleague if the way he spoke about, for instance, raising voices, which is basically Convention 87 and 98, give the opportunity to workers to collectively organize and to make sure that what we call in ILO terminology, that there is voice representation by workers. Because at national level, of course, you have your Trade Union Act, but despite the fact that legally everything is perfectly alright, that any 7 workers can organize to join and form a union, at the same time, in practice, there is a kind of anti-union atmosphere in this country, and this is a global trend. So the fact that India is looking into the ratification of Convention 98 is a very positive movement. Now also I want to say a few things about the ILO. Since 1 October we have a new Director General. It is no longer Juan Somavia, who came from Chile. Now we have Guy Ryder has been elected as the new ILO Director General. He is a British citizen, and he is originally coming from the International Trade Union movement. He is going to, as any new Director General in any organization, he is going to reorganize the ILO. And one of the priorities that the ILO will deal with more firmly is going to be international migration. Because if you look, for instance, in Asia, to the ILO capacity of colleagues who are dealing with migrant issues, already every specialist or every ILO official is more or less deemed to know how to deal with migration issues. But we only have in entire Asia, based in Bangkok, one specialist who is exclusively a migration specialist. One for entire Asia. And you can imagine that in that way we cannot do our work seriously. Actually, the colleague who is based in Bangkok, his name is Barua. What is his name again? Nilim Barua, or Ek Bharati Admi hai, Assamse. So he is based in Bangkok. Then some of you, or many of you, already have been mentioning this employment agencies, staffing agencies, recruitment agencies problem. There is a convention at the ILO 181. India is seriously looking into the ratification of this convention, not only regarded to international migration, but also to national migration, domestic migration, as you have also been indicating. One golden rule that the ILO has already in its other migration conventions, which you also mentioned, 97 and 143, is that yeah. Aya or Gaya. Gaya or Aya. And one golden rule is that a worker should not be charged any of the recruitment costs. So there can be small charges for any worker, for instance, for the insurance, for the overseas travel, which would amount to a few dollars, maybe $20, $30, $50. But the principle is that this recruitment of migrant workers should be free of cost for migration workers. You can, of course, imagine that this is almost like the concept of decent work. It is almost too beautiful to be true. But these are the international rules that we have to stick to. Then what you mentioned, the Domestic Workers Convention, is just adopted by the International Labour Conference last year. It takes 2 ratifications for any convention to come into force. The Domestic Worker Conventions 189 has meanwhile been ratified by 2 countries, Uruguay in Latin America and the Philippines. So we are now hoping, we are now hoping that we will have more and more countries ratifying this Convention 189. Already in the preparation of this new convention, we have seen that domestic workers have been included in your minimum wage boards in several states, if I'm not mistaken, Karnataka, Andhra Pradesh, Maharashtra. So there is movement already in protecting their rights. Then I would also like to draw your attention to a 1998 declaration that was adopted by the ILO on the fundamental principles and rights at work, which basically says that if any country has not ratified all the 8 core conventions of the ILO, like India has not ratified the Child Labour and the Freedom of Association conventions yet, still there is an obligation arising from the membership to the ILO that you respect, promote and realize the principles that are underlying these conventions. So in that way we tried, as the International Labour Organization, to create a minimum platform of respect for basic labour rights by all member states. Now what is relevant that I'm going to tell you about how to take action as a trade union. Every country that ratifies a convention has to report back to the ILO to tell how this convention is being applied. For these 8 core conventions and a few others, 4 other conventions, every 3 years the government of India has to send in its report. This of course applies to every member state. At the same time, this is what we call, and then this is what we call an Article 22 report, because it makes a reference to Article 22 of the ILO Constitution, in which this reporting obligation is being mentioned. But at the same time, trade unions and employers organizations do have the right to send their own comments. And there is no time limit, there is no cluster period within which these these Article 23 comments can be sent by trade unions and employers organizations. It can be done at every point in time. And it basically only meets the conditions of receivability are very simple. So trade unions already can make use of this, what we call Article 23 procedure. And I can tell you that many unions do make use of this procedure. You can do it at national level again, but you can also file these comments on the application by one of the Gulf states or Malaysia or whatsoever if you feel that migrant workers from India's rights are being infringed one way or another. Then we also have a special complaint procedure, again which is exclusively at the disposition of trade unions and employers organizations, which we call the representation procedure. And we call it representation because we also have a complaint procedure, but the complaint procedure is from one state to another, which is not used very often. But representation in fact means complaint. So as a union you can file this representation saying the violation of ratified convention A, B, C if, and again the conditions for receivability are quite light, if the complaint is being approved, then the ILO will constitute a tripartite tri-member committee, one worker, one employer and one representative of government to actually investigate this representation. This is a process of dialogue. The whole supervisory procedure of the ILO is a process of dialogue within international law. Basically the only weapon that we have is increased dialogue to make sure that we understand each other, that trust relations are being built, but also that through dialogue we get the adequate facts above the table and that we are not reasoning on the basis of non-proven facts. Sometimes people call the ILO a paper tiger or a tiger with paper teeth because we do bite but it doesn't really hurt. We cannot call Barack Obama or whatsoever to bomb Saudi Arabia because workers' rights are being violated. So we have to go through this process of mutual dialogue. So this representation procedure can be used if adopted. The recommendations by this tripartite special committee, it will go to the ILO governing body, of which India, the government of India, is a permanent member. And then once the governing body is adopting the recommendations, the countries that are being mentioned in these recommendations are supposed to follow up these recommendations. Of course, when the recommendations are not being followed up, we face a problem and we have to see how we can deal with it. But we take it at an ad hoc basis. Some countries are very eager to follow the recommendations, some others are more reluctant. I was working at the International Labour Training Center in Turin in Italy in 1999, and there we organized a meeting with the 8 Gulf countries, or 6 Gulf countries, for the first time in history that they were being trained on these 8 core conventions and their provisions. So actually their awareness about basic fundamental human labor rights is very young. And it is also something that we have to nurture, and we also have to put them under pressure that they better know what these rights are and how they can apply them. And then finally, we have a special freedom of association procedure whereby the ratification status of conventions is irrelevant. It's a special committee on freedom of association commission, which is composed of 10 members, 3 workers, 3 employers, 3 government representatives, and it has an independent chair. So even India has not ratified the conventions 87, 98 on freedom of association. Most of the Gulf countries have not, but despite the fact that there is no ratification, you can file this complaint. India, in its history since 1927, or 1940 something, that this freedom of association procedure is existing, has filed more than 60 complaints, but always related to India. And worldwide we have had more than 3,000 complaints about freedom of association. So if you, for instance, try to set up a small union or a Sangatan or an organization or whatever the name is, but some kind of collective action by workers, and it would be blocked by the government of Saudi Arabia, you can use this special freedom of association procedure. So this is just to indicate to you that there is, under the ILO supervisory procedures, there are very concrete measures that you can take to draw the attentions of the ILO supervisory bodies, which at the same time means that the supervisory bodies of the ILO will communicate these issues to the relevant governments, whether it is India, Saudi Arabia, Kuwait, or whatsoever. And I can tell you, I have seen with my own eyes how the action of trade union has resulted in concrete activities at country level. For instance, in India, this is a different matter, but by matter of example, we do have a specific, the ILO has a specific project which is working on manual scavenging based on caste-based discrimination convention 111. The fact that we are having this project is purely due to the action that was taken by trade unions under this supervisory procedure. So, very effective instruments, tools these are for trade unions. Then, finally, let us have a look at which Gulf countries have been ratifying which ILO fundamental conventions, and actually you can see that their record is not too bad. All of them have ratified at least 4 or 5 of the fundamental ILO conventions, which means that as an Indian trade union, you feel that there are either practices or practices of discrimination which violate national law, or that there are practices of forced or bonded labor, and we have heard from the specialists, from the Swami as well, that there are issues of advance which would amount to bonded labor, which could be forced labor. There are wage problems, passports are being taken away. So there are ample facts that we can use stating these members of practices of either discrimination or forced labor. That is crystal clear from what has been presented this morning. But even in Kuwait, or the fact that you can use this Committee of Freedom of Association procedure in all these countries, even if they have not ratified Convention 87/98, but the Article 23 procedure you can also use for Kuwait, which has ratified 87 and 98. And of course, in the Gulf countries are very reluctant to recognize the right to trade unionism, because in some countries the migrant labor force is much larger than the indigenous population. So you create kind of political forces by having trade unions, but at the same time, by ratifying this convention or acknowledging this 1998 Declaration of the ILO on Fundamental Principles and Rights at Work, as members of the ILO, they do have the obligation arising out of international law to recognize trade unionism. So, this is all I wanted to tell you, that you can use this Article 23, Article 24 procedures in case of ratified conventions. I imagine that forced labor discrimination would be most obvious for filing a complaint, but even if you feel that there is underage work, the child labor conventions can also be used. And then generally you can use the Committee on Freedom of Association, even there where countries have not ratified these conventions. So I hope that this has been clarifying a little bit how you can use the ILO, how the ILO can be made actually effective to take concrete and practical measures to do away with all these labor law violations. Dhanyawad, Meharbani, and have a nice day. Thank you very much.